so many teams, faculty advisors, judges, timekeepers, and judge assistants in regional organizers and sponsors and everybody. Thank you very much for all this work. We are going to have today sitting in front of Judge Skotnikov, Judge Joan, and Judge Donoghue. So I want to inform you who is, here's my co-chair, Manfred Lachs. And I want to inform you that the author of the program is Professor Dr. Hanqin, who is, was assisted by Joan in the drafting of the program. And now I would like to invite Joan to give a summary of.
I would like to thank all who participated in finalizing the case, especially the Moot Court Committee, and particularly to James Randleman. With your permission, I would like to dedicate this case to my late academic teacher, Professor Vladimir Popov, who, as you know, was always convinced that the international space and telecommunication law can never develop without its natural basis, general international law. Because the case is known to everyone, I shall confine on the very basic repetition of the facts. The Agrarian Federation and the Commonwealth of many are neighboring states with a long history of competition, diverging political systems, alliances, and disputes. AGRA has developed a navigation system, SENAV, hosted on board a variety of commercial satellites. The SENAV capabilities have been employed by the Agrarian military as well as the international private sector. Unbeknownst to AGRA, the SENAV signal was used also by the Malian military with unauthorized Malian-produced SENAV equipment tools. In early 2015, a Malian corporation, SEN Communication, received authorization from the Malian government to begin development of the X-12 satellite system. The X-12A and X-12B satellites were launched at 6-month intervals from a floating platform in waters of the Hanqin archipelago by an international commercial launch service consortium which included entities incorporated in AGRA. The X-12 satellites were placed in highly elliptical orbits with their apogees located above the territories of AGRA and Leonid. In mid-2016, AGRA noted that its receivers began to suffer from strong electromagnetic interference, and as a result, the system began to have difficulty accessing the SENAV signal. The interference coincided with the overflights of the Malian satellite over AGRA, and all the affected SEER receivers which were within the communication footprint of the satellite. As a result of the interference of the SENAV signal, an Agrarian armored area vehicle equipped with a navigation receiver has crashed at the military base, destroying the vehicle as well as the building and the base, and killed 2 military personnel on the ground. The Agrarian Foreign Ministry issued a demarche to the Malian authorities demanding that Mali take immediate action to prevent the transmission of signal from X-12 satellites that were causing or could cause harm to AGRA's use of the SENAV system. However, the Mali's foreign minister refused to take any responsibility for the interference. Therefore, AGRA sought redress for its complaints about the interference to the International Telecommunication Union and requested that and many accede to the optional protocol on compulsory settlement of disputes. Many rejected it. Ankara also raised concern about the X2 satellites before the United Nations Committee on the Peaceful Uses of Outer Space, and also sent an official letter to the UN Secretary General informing him about the situation. Furthermore, it formally requested the UN Security Council to undertake measures with a view to prohibiting the attacks against its communication networks. However, one permanent member state of the Security Council issued a statement that it would veto any resolution against them. Subsequently, the Security Council letter was tabled without a vote. During this period of time, Ankara developed a second generation of Athena navigation satellites, which were designed to counteract and neutralize the effects of the interference. While these new satellites orbited in a near conjunction with the Maniac satellite, this satellite malfunctioned and began to spin. Within 2 weeks, the Maniac satellite re-entered the Earth's atmosphere and was destroyed. With the destruction of this satellite, the interference of the signals ceased. In order to reduce the potential for hostilities among the parties and resolve their disputes, Ankara and many have decided to submit this issue for resolution to the International Court of Justice. Ankara requests the court to adjudge and declare that Mali is liable under international law for the harmful interference preventing access to the CNET satellite navigation. Ankara acted in conformity with international law by disabling the X-12A satellite. And third, Mali is liable to Ankara for the loss of the unmanned aerial vehicle, the damage to the military facility, and the death of the 2 apparent military persons. Mali requests the court to adjudge and declare that Mali is not liable under international law for any interference preventing access to the CNET signals. Ankara violated international law by disabling Maniac satellite, resulting in its destruction. And third, Mali is not liable to Ankara for the loss of the unmanned aerial vehicle, the damage to the military facility, and the death of the 2 apparent military personnel.
In the case concerning satellite electromagnetic interference, the appearance Federation and the Commonwealth of Leonid. You read your written clearings, you know the facts. It is a fact-intensive case. I think that my colleagues as well as myself would have some questions addressed to you and would possibly interact when you speak. And most probably these questions will be related to the questions of law rather than facts. And with that, I will give the floor to the agent of the Hanqin situation.
Mr. President, distinguished members of the board, my name is Leonid. I am agent appearing on behalf of the applicant, Federation of Kerala, and it is an honor for me to appear before this court. Over the next 18 minutes, I will be addressing this court on key aspects of our case with respect to the issue of Mali's liability under international law for electromagnetic interference denying access to the CNAT satellite signals. I will then leave the floor to my co-agent, Mr. Soman Kumar, who will, in the subsequent 22 minutes, address this code on the issue of ACERA's liability under international law for disabling the express satellite and the issue of the loss of the unmanned alien vehicle, the damage to Acadian property, and the loss of life of Acadian military personnel. As consequence, we reserve 5 minutes for rebuttals. Mr. President, may please this quote. With my first submission, there are 3 propositions that I urge this court to consider. First, that in the present case, indirect evidence can be relied upon and it is conclusive to lead to the conclusion that the interference was caused by the expelled satellite. Second, that the acts of self-communication are attributable to the Commonwealth of Maine. And third, that such acts of electromagnetic interference are in violation of international law. Allow me, Excellencies, to substantiate the first proposition, which is that indirect evidence can be relied upon in the present case. As can be evidenced from the merits judgment of this court in the Skotnikov case, the court has allowed recourse to indirect evidence when 2 conditions are met. First, when the all possible direct evidence is in exclusive control of the opposite party, and second, when the evidence that is then led does not contradict any direct evidence or uncontested fact. In the present case, Your Excellency, these conditions are met as SAN Communications is a Mainian entity operating out of Maine, and therefore the Federation of ACERA has no access to any possible direct evidence. The evidence that we seek to lead shall not contradict any direct evidence or uncontested fact. Coming to the circumstances of this case, Your Excellencies, paragraph 8 and paragraph 16 of the complaint lay down the circumstances which help establish the source of this electromagnetic interference. The first fact, Your Excellencies, is that there was no interference with the CNAV signals before the launch of the expelled satellites. Second, that the apogee of these satellites were located over the ACERA. Third, that the electromagnetic interference coincided with the overflight of the expelled satellite over ACERA and affected only those receivers which were within the communications footprint of the expelled satellite. Finally, and most importantly, Your Excellencies, these interferences ceased with the destruction of the expelled satellite. The court in the Skotnikov case said that a party that does not have direct access to direct evidence should be allowed liberal recourse to inferences of fact, and special weight should be given to such indirect evidence when it leads to a single conclusion. All of these circumstances lead to a single conclusion that the interference was caused by the expelled satellite. The second aspect which this court looked at was the motive. In the Skotnikov case, the court noted that Albania had a particularly hostile attitude towards the presence of foreign ships in its territorial waters. Your Excellencies, in the present case, the party, SAN Communications, which launched the expelled satellite, owned lucrative stock options in an entity called Peabody Enterprises. Peabody Enterprises, Your Excellencies, is an entity that has an interest in mining in the Langhans Archipelago. The Langhans Archipelago, Your Excellencies, is a claimed economic zone between ACERA and Maine, and that is allowing such the result of this interference, Your Excellencies, was that ACERA lost the ability to monitor the activities in the Langhans Archipelago, and the complaint clearly states that Peabody Enterprises successfully drilled in the Langhans Archipelago after the interference denied ACERA the access or the ability to monitor the Langhans Archipelago. This, Your Excellencies, is motive for SAN Communications to interfere, and therefore the fact of the source of interference stands established that the interference.
It is interesting that you're constantly referring to the interests of private entity, SAN Communications, and you're not referring to the interests or motives of the respondent. Are those separate? And what the law says about this type of situations?
Thank you for your question, Mr. President. Your Excellencies, this question brings me to the question, to the aspect of attribution in the present case. We seek to submit that the state of Maine, all the actions of said communications are attributable to the state of Maine. We rely on Article 6 of the Outer Space Treaty to establish that all acts of said communications are attributable to the state of Maine. Under the Outer Space Treaty, Your Excellencies, the parties to the Outer Space Treaty have reached on a special consensus or a special agreement that private space activities shall be allowed in outer space only when the state whose nationals these parties are take full responsibility for the activities of their nationals. Therefore, as the law stands, state parties bear complete responsibility for the activity of their nationals in outer space. Said communications, Mr. President, is a Mainian entity, and therefore, over and above, by a special agreement, the state of Maine has agreed to be bound by all the acts and be responsible for all the actions of said communications.
What I read in the case file, suggests that it may be argued that the respondent was not the only launching state. That there was a consortium, international consortium with participation with Akira as well. And I noticed that in your meetings you avoided this issue. What are the legal implications of the fact that there were so many, maybe not so many, but a few launching states has been argued by the respondent? And please don't bring up the issue of the registration because it's a different one.
Mr. President, brings us to a very crucial juncture in the present case, which is the difference between Article 7 of the Outer Space Treaty and Article 6 of the Outer Space Treaty. The fact and the responsibilities of a launching state are governed by Article 7 of the Outer Space Treaty, in which case there can be more than one launching state as per the definition of Article 7. However, the state responsibility is governed by Article 6, which is for its national. Even if, that is a position that my co-agent shall argue in denial, even if the Federation of Akira is considered a launching state, the effect of that would be that it would come within the regime of Article 7. The difference between Article 7 and Article 6, Your Excellencies, is that Article 6 makes states responsible for violation of international law without an event of damage. Obligations under Article 7 are contingent on the fact of damage. Therefore, this case has two strands. The first strand is the causing of electromagnetic interference in itself is a violation of international law, independent of the fact of whether any damage was caused by it or not. Whereas, any damage caused by such electromagnetic interference would be regulated by Article 7. What I seek to address this code upon is the causing of electromagnetic interference alone, which is the responsibility of the state whose nationals are conducting the activities in outer space. Once this satellite was launched, the involvement, if any, of the Federation of Akira was limited to putting this satellite in orbit. Once this satellite was launched, all the activities, all its actions were under the exclusive control of said communications, which is a Mainian entity. Therefore, there may be, Mr. President, more than one launching state, and the second launching state may be the Federation of Akira. However, there is only one responsible state in the present case with respect to the legality of this electromagnetic interference, and that is the Commonwealth of Maine.
Council, if you think Akira could also be considered as a joint launching state, why make a distinction of liability between the two parties?
Your Excellency, we believe that, and as my co-agent will argue, that Akira is not a co-launching state. The distinction that I implore this bench to consider is that the consequence, the operation of the liability convention, or the determination that this court shall make on the damage that is caused under the Liability Convention is independent and is separate of the question of electromagnetic interference. Your Excellencies, the first step of this case was the causing of electromagnetic interference. The second step of this case was damage, if any, which was caused by this electromagnetic interference. And the Liability Convention is a very specific regime, Your Excellencies. It is a victim-oriented document agreed upon by the state parties to provide quick relief to the parties affected by the damage. Therefore, the main thrust of the Liability Convention is to provide compensation at the earliest possible juncture. However, the legality or the causation of this electromagnetic interference is an aspect in itself independent of responsibility that is covered under Article 6 of the Outer Space Treaty. Your Excellencies, therefore, the thrust of my submission is that the causing of such electromagnetic argument. Your Excellencies, both parties to this dispute are parties to the ITU Constitution. Under the ITU Constitution prohibits harmful interference with the signals of another satellite. The Constitution defines harmful interference as interference which endangers the functioning of a radio navigation service or of other safety service, or seriously degrades, obstructs, or repeatedly interrupts a radio communications service operating in accordance with the radio regulation. Your Excellencies, as can be evidence from the contrary, the interference denied the carrier access to CNAV satellite signals as it repeatedly interrupted with the receivers gaining access to the satellite, to the CNAV signals. And therefore, the act of causing harmful interference in itself is a violation of the treaty or of the Constitution of the International Telecommunications Union, which both parties to this dispute have agreed to. Further, Your Excellency.
Counsel, I'd like to ask you to address the assertions that you made in your written meeting that men's actions were a use of force. I'd like to understand whether your view is that all electromagnetic interference and all harmful interference is a use of force, and if the answer is no, if you believe that it is only sometimes a use of force, where should the court draw the line between interference that is not a use of force and interference that is a use of force?
Thank you for the question, Your Excellency. Your Excellencies, my co-agent shall deal with that submission in detail, but the Federation of Akera's stand with regard to this is all electromagnetic interference is not use of force, but when it fulfills the criterion for use of force, which is such interference when it has the effect of affecting territorial integrity and political sovereignty of the state, and when it has the effect of use of force, then it should very well be considered use of force. And that is a submission that my co-agent shall address to this court. That when it does fulfill that threshold and that effect which has been laid down by this court, then regardless of the means of causing such effect, the effect in itself should be considered a use of force, or if it is escalable, or if it can be escalated, it should be even considered an armed attack. And that is something that my co-agent shall address this court on.
I'm not as familiar with the ITU regime as you are. It seems to me that this regime, as far as the interferences are concerned, it is a regime of negotiations, seeking solutions. It doesn't envisage liability per se, probably doesn't exclude it, but it doesn't. So it's really hard to equate this regime, which is so, I would say, friendly and cooperative, to the use of force. So you make a big leap here, because apparently the ITU regime doesn't see it, the electromagnetic interference per se, as use of force.
Your Excellencies, there are four aspects to that question. The first aspect is a treaty right that the Federation of Akera has to operate its satellite independent of the electromagnetic interference, and that is governed by the constitution of the International Telecommunications Union. Now, this obligation can be found in the Outer Space Treaty as well, Your Excellencies, where under Article 9, which states that states should operate or conduct their activities in outer space with due regard to the interests of other states. Your Excellencies, a codification of this can be found in the principles of remote sensing. The principles of remote sensing were agreed unanimously by all the states, which give every state the right to remote sense its own treaties, and that was the purpose of the CNAV satellite. So therefore, these are the obligations under international law, independent of the question of use of force, which the Federation of Akera is entitled to, and which is the thrust of my submission, which is that these obligations have been violated by the Commonwealth of India, and therefore these should be considered violations of international law, independent of whether this court holds such electromagnetic interference to be use of force, independent of whether this court finds damage and determines questions that arise under the liability convention. Your Excellencies, the fact is that after the fact of electromagnetic interference, what happens then? Or what are the effects of causing such electromagnetic interference? And what was the effect in the present case shall determine whether causing of such electromagnetic interference will be considered use of force, armed attack, and on the basis of that, whether the Federation of Akera has any right to self-defense under Article 51 of the UN Charter. That is a submission that my co-agent shall address this court upon. If Your Excellencies are satisfied, I seek your permission to call upon my co-agent to address this court.
Thank you very much.
Thank you, Your Excellencies. It was an honor to ask for this discussion.
Good afternoon, Your Excellencies. Through the course of my submissions, I shall be dealing with the second and the third issues that we've raised as part of our legal submissions. The first issue that I shall deal with concerns Akera's liability or Akera's actions in disabling the X-ray satellite and whether these are in consonance with international law. In dealing with this issue, Your Excellencies, I shall address this bench of questions of whether or not this action amounted to an illegal use of force, and if it did, was it justified under Akera's right to defend itself? The last question that we have raised before this bench, Your Excellencies, is Maini's liability to compensate Akera for the loss of life of Akeran citizens and the damage that was caused to Akeran property in the form of destruction of the unmanned aerial vehicle and the destruction of the military facility. Beginning, Your Excellencies, with the first issue, which considers Akera's disabling of the X-ray satellite, we have three broad submissions that we would like to make before this court. Firstly, that the electromagnetic interference in itself amounted not only to an illegal use of force, but also amounted to an armed attack. Secondly, Your Excellencies, this electromagnetic interference that was caused by said communications is attributable to the state of India. And thirdly, Your Excellencies, that irrespective of this question of attribution, we believe that Akera's action in disabling the X-ray satellite, which was the source of the electromagnetic interference, is a legitimate exercise of our right to defend ourselves, enshrined both under Article 51 of the United Nations Charter and under customary international law. Your Excellencies, beginning with the first argument that I seek to present before this court. There is a prohibition under both the United Nations Charter and customary international law on an illegal use of force. We submit that when any court must determine when force is being used illegally, they must consider the effects of these actions. And the effects that we refer to, Your Excellencies, are whether there was a violation of another state's territorial integrity, political independence, or their sovereignty. We submit, Your Excellencies, further that electromagnetic interference has these effects. And in order to prove this to Your Excellencies, we would first like to draw your attention to General Assembly Resolution 3314, which defines aggression. Your Excellencies, in Article 3C, aggression is inter-area defined as a naval blockade of a port. We submit, Your Excellencies, that given that a naval blockade is considered a use of force, an electromagnetic interference of a satellite having the same effects as a naval blockade should also be considered as an illegal use of force. The particular effects that we refer to, Your Excellencies, are the following. A naval blockade does not allow the to and fro movement of any vessels from or to a port. This particular electromagnetic interference not only impacted the functioning of the satellite, but also all systems associated with the satellite. Your Excellencies, the compromise unequivocally states that Bagheera's economy, all its international trade, and a significant portion of its international shipping was dependent on the CNAV signal. And once the electromagnetic interference from the X-ray satellite began, and once it got more invasive and more pervasive, Bagheera's economy suffered significant losses, which is very similar, Your Excellencies, to what happens in a naval blockade. Particularly, Your Excellencies, we would draw your attention to the blockade of the Straits of Tiran by Egypt in the 1950s. The Security Council in that case, and further the General Assembly in its plenary meeting, clearly was of the view that not only does the naval blockade that has these effects amount to a use of force, but it also triggered Israel's right to defend itself against that blockade.
Council, I read through this discussion in your brief regarding the naval blockade, but I was puzzled by it because it seems to me that you are focusing attention on the characterization of a naval blockade as a use of force without taking account of the threat of use of force that is presented by a naval blockade. So can you offer an example, other than a naval blockade, to support your notion that electromagnetic interference can be regarded as a use of force? And can you address the question I posed to your co-counsel about what line should be drawn between electromagnetic interference and not use of force and that which crosses over to become use of force?
Your Excellency, in answer to your first question, which is apart from naval blockade, what are the examples you choose to rely on? We submit, Your Excellencies, that jamming and especially frequency-based jamming technologies have been a part of the military strategy of states for a long time, ever since these technologies were conceived. In the Gulf, in both the Gulf Wars, the United States of America made heavy use of jamming technologies to jam the radar capabilities of Iraq so that their F-22s and all other naval vehicles could in fact commence the bombing of Iraq. We further also submit, Your Excellencies, that the General Assembly in resolutions beginning with Resolution 53/17 of 1998 and cyber-based technologies that include frequency jamming and other cyber-based technologies have the potential to impede on international peace and security. We submit, Your Excellencies, that these resolutions do not label electromagnetic interferences as uses of force. But given, Your Excellencies, that this is a unique case, and given the fact, and this is the answer to the second question of Your Excellencies, given that the effects of this electromagnetic interference are akin to other uses of force that have occurred in the past, it is our submission that purely on the effects test alone, which this court has adopted in the Nicaragua judgment, in the oil platforms judgment, and even in the case between the Democratic Republic of Congo and Uganda, we submit that the electromagnetic interference amounted to a use of force. Your Excellencies.
Counsel, in your own argument relating to use of force and self-defense, in the field of outer space, where those principles of cooperation and consultation would play? And before any investigation being conducted by Akira regarding to its loss, and immediately you take action as self-defense, where you can find how you assess the principle of cooperation in the field of outer space.
Thank you for your question, Your Excellencies. Your Excellencies, in response, we would like to draw your attention to paragraphs 10, 12, and 13 of the conclusion, which indicate that before embarking on our right to defend ourselves, we attempted to undertake not only bilateral negotiations with the respondent state, but also approach the Committee on the Peaceful Uses of Outer Space. We attempted to resolve this dispute under the procedures of the International Telecommunications Union, and we also attempted to approach the United Nations Security Council. All of these attempts, Your Excellencies, were unsuccessful, which is why, left with no recourse, it became absolutely necessary for us to launch the CNAP satellite to counteract electromagnetic interference.
So basically you are equating the electromagnetic interference in this particular case with an armed attack. With an armed attack.
Indeed, Your Excellency. Your Excellency, in order to substantiate how the EMI amounts to an armed attack, we would seek to draw your attention to the Nicaragua judgment and the oil platforms judgment, which when explaining what an armed attack is, give us the scale and effects test, Your Excellencies. We submit, Your Excellencies, that in each individual case where an armed attack is alleged, it is a subjective determination before this court. But the bench in the Nicaragua case, in paragraphs 191 to 197, suggested a two-pronged test to determine whether sufficient gravity has been met. The first prong was the vulnerability of a state to a particular action, and the second prong was the actual effect and how this vulnerability played out practically. We submit, Your Excellencies, that in light of the fact that the CNAP signal was integral to the Agueran economy, was integral to the political independence that Agueran exercises, not only with reference to its internal political scenario, but also with reference to our military capabilities to patrol our own waters. We submit that we were highly vulnerable in the sense that any damage to the satellites that were transmitting the CNAP signal would directly impede Agueran political way of life and Agueran economy significantly. Something that the compromise also unequivocally states in paragraph 9. Further, Your Excellencies, in the oil platforms judgment in paragraphs 64 and 72, the court said that an armed attack need not occur over a large period of time. Even a single attack may be enough, because each factual circumstance, Your Excellencies, differs. We submit that in this case, the continuity of the electromagnetic interference, the significant damage to the Agueran economy, and the significant impairment of our political independence equates this particular interference to an armed attack. Further, Your Excellencies, even if this court were to hold the view that there is no armed attack, we seek to rely on the fact that rather than legitimately exercise our right to defend ourselves, we've exercised a right to a forcible countermeasure in order to make the respondent state follow the legal procedures and follow the law as it were.
Counsel, what do you mean by forcible countermeasure?
Your Excellencies,
Where you find this concept in international law?
Your Excellencies, for forcible countermeasures, we seek to rely on Judge Sima's separate opinion in the oil platforms case, where Judge Sima noted a slight lacuna in the way that the law on use of force and armed attack proceeds. An armed attack is a particularly grave form of use of force, but all uses of force may not necessarily amount to armed attacks.
But Counsel, you have to make clear, are you arguing on the basis of a self-defense against armed attack, or are you arguing on the basis of countermeasure as circumstances that preclude the wrongfulness of your act? You can't mix them up. There are two different legal concepts.
Indeed, Your Excellency. Our submission is as follows, Your Excellency. We submit that our actions in disabling the XYZ satellite were a legitimate exercise of our right to defend ourselves. In the scenario that this court does not agree that this electromagnetic interference amounts to an armed attack, we still believe our actions are legal and justifiable as forcible countermeasures.
Just ask whether the argument not only with Judge Sima's separate opinion, but also with this court's judgment on Chico. And there the court addressed the issue of one of those conditions, which must that's the word used, must be complied with, is that any countermeasure should be reversible. This excludes the idea of anything forcible. If you go and study the draft articles on this state responsibility, then you also will see a number of conditions. One of those conditions is that norms in use cognizance cannot be violated. If use cognizance is violated, it is not a countermeasure. But in your case, if it complied with, it is self-defense. So I think that you're trapped a bit in these contradictions. But I think that countermeasures are not popular as such, but forcible countermeasures would be something which would run counter the thinking and the decisions of this court and the draft articles, which are very related to the document.
Your Excellency, just a brief response to the question which you posed. Forcible countermeasures as envisioned and as is our submission in Judge Sinha's separate opinion are distinct from the legal regime of countermeasures under the Articles of Responsibility of States. It is not our foremost submission that we seek to rely on forcible countermeasures. It is in fact the last argument that we would present to this court in case this court were to hold that self-defense as a right wasn't triggered. Our primary submission, Your Excellencies, is that this electromagnetic interference amounted to an armed attack. And irrespective of whether it was caused by sending communications, and irrespective of whether it was attributable to the state of meaning, we believe that under the law of self-defense, we have a right to disable the extra base activity, Your Excellencies. And in this regard, we would seek to draw your attention to the following, Your Excellencies. Security Council Resolutions 1368 and 1373 of 2001, the plenary records of the 56th session of the General Assembly, all indicate that even if a non-state actor, which sent communications is responsible for an armed attack, states still have a right to defend themselves against this non-state actor. The only limitation that has been placed on such an exercise of a right to defend itself is that in doing so, the impact on another state must be minimal, which was stated in the advisory opinion that this court rendered on the legality of construction of the wall in the occupied Palestinian territory. It is our submission, Your Excellencies, that
your reference to non-state actors is interesting and maybe even fashionable these days. But how does it work in this particular case when we deal with the outer space law? And whatever space object is launched by a private entity remains under jurisdiction and control of the state. So how you can base your argument on the idea that sync communications is a kind of non-state actor, like in James Bond movie, Spectre, whatever. One understand organization, but it's not. It cannot be. So why are we resorting to this argument at all about non-state actor?
we believe, Your Excellencies, that even though the regime of Article 6 of the Outer Space Treaty makes states responsible for all actions of non-state actors in outer space, there is a possibility that given that law relating to an armed attack is a peremptory norm, is a jus cogens norm, lex specialis regimes may or may not occur. The argument that we still have a right to defend ourselves against non-state actors, Your Excellencies, is only applicable in case this court were to rule that Article 6 does not govern questions of attribution when it comes to armed attacks. Again, Your Excellencies, it is our primary submission that Article 6 should in fact govern the behavior of states vis-a-vis non-state actors that are incorporated in them. But even if it doesn't, Your Excellencies, in in the interest of time, it is our submission that our right to defend ourselves was exercisable either against self-communications or even against the state of being if it's responsible under Article 6.
Also, I'd like to take you to the third submission. And in your written meetings, you say managing or alternatively under Article 3 of the Liability Convention, and then you continue to say, additionally, it's liable under general principles of international law. By contrast, your opponents emphasize the idea that the regime of space law is a regime of lex specialis that governs issues with particular rules that are designed to address space law. I'd like to know whether you agree that there is a doctrine of lex specialis here that governs, and in particular, whether I'd like you to explain to me how general international law could provide additional bases of liability beyond those that are set out in Articles 2 and 3 of the Liability Convention.
Your Excellency, we do believe that the Outer Space Treaty and the Liability Convention operate as a lex specialis regime. Our submission that there is additional liability under general international law, including the Articles of Responsibility of States, stems from our understanding that a lex specialis regime only overrides a lex generalis regime when the two are distinct. It is our submission that while standards of attribution may differ slightly under this regime of the Outer Space Treaty or the Liability Convention, certain sections of the Liability Convention, such as Article 3 of the Liability Convention or even Article 7 of the Outer Space Treaty, established a fault-based regime for liability. The argument that general international law is applicable is only again in the circumstance that we are precluded from making a claim under either the Liability Convention or the Outer Space Treaty, something we believe we're allowed to make a claim under it. Specifically, Your Excellency is referring to Article 2 of the Liability Convention. We submit that Article 2 establishes an absolute liability that is for any damage that is caused on Earth by a space object. It is our submission that the operative word here, Your Excellencies, is caused, and the concept of causation is seen under Article 2 of the Liability Convention.
Just so that if our court would decide, for example, that under Article 2 it is necessary to establish that there was physical impact, are you taking the position that there could nonetheless be liability without physical impact that under general international law?
Your Excellency is not only under general international law, we seek to submit that non-physical damage or damage that is not caused by collisions was also envisioned under the Liability Convention. Specifically, Your Excellencies, if we may draw your attention to footnote 188 of our written submissions. During the preparatory works of the Liability Convention, the word collision was replaced by cause, which is a clear indication that even though the drafters initially envisioned all damage to be caused as a result of collisions, the replacement of the word collision by cause indicates and is also in consonance with the statements made by the French and the Italian delegates that not all damage caused by space objects may be physical. However, Your Excellencies, even if the Liability Convention and the Outer Space Treaty does not cover non-physical damage, it is our understanding that general international law will then come to our aid, and under the regime of fault liability, such damage will be covered, Your Excellencies. And in order to I see Your Excellencies that my time is elapsed. Much obliged, Your Excellencies. Your Excellencies, in terms of general international law, we seek to rely on three cases: the Trans-Fiber arbitration, the Amorphous International Financial Corporation versus Iran arbitration, which specifically said that property does not only mean tangible assets but may also be intangible, and the liability regime that was established in the Factory of Chorzo case, which says that if there is a legal duty, which there exists under the Outer Space Treaty, the Liability Convention, and even the ITU Constitution, if there's a breach of this duty, as already been argued by my co-agent, which there was in causing the EMI, and if there is damage resulting, which is both in terms of not being able to operate our satellite and also physical damage in the form of destruction of property and loss of life of citizens. We believe that even under the four-based regime, whether under the Outer Space Treaty or general international law, the respondent state is liable to the applicant state. Thank you, Your Excellencies.
Now let's turn to the respondent.
Thank you, Mr. President, Your Excellencies, and may I please the Court. Здравствуйте. Ni hao. My name is James Burleson, and along with my co-agent Jessica Fernandez, I represent the respondent in this matter, the Commonwealth of Benin. Your Excellencies, I will address the first and third submissions to this Court using the first 23 minutes of our time to demonstrate why Benin is not liable for the inaccessibility of the CNAV signal. And second, showing why Benin is not liable to Akira for the crash of an unmanned aerial vehicle. My co-agent, Ms. Fernandez, will then use the next 17 minutes of our time to address the second submission to the Court, demonstrating how Akira violated international law when it disabled and destroyed the X-12A satellite. If we may, we then like to reserve the final 5 minutes of our time for survey. Your Excellencies, as to the first issue before this Court, Benin is not liable to Akira for the inaccessibility of its CNAV signal for any of three reasons, which I will discuss in the following order. First, Benin is not at fault under an objective or subjective standard, and thus cannot be held liable for the damages alleged. Second, the damages alleged are not contemplated under international space law because they are not caused by a space object and are not physical damages, those for the inaccessibility of the CNAV signal. And finally, even if these damages are compensable under outer space law, Akira is a joint launching state and thus has impliedly consented to the X-12 activities and any harmful interference that results therefrom. As to the issue of fault, Your Excellencies, it is first important to note that opposing agents have spent a great deal of their memorials and their oral argument discussing that the X-12A was the source of the evil. Benin concedes that the facts now available to the Court do lead to the conclusion that the X-12A was the source of the EMI. However, Benin does not concede that it is at fault or liable for the interference that Akira experienced. As noted by the International Law Commission in its comment to Article 2 of the draft articles on state responsibility, there is both an objective standard or a subjective standard that can be applied depending on the circumstance of the case to determine the fault. The objective standard being a breach of international law, as has been applied by this Court in various cases, such as Porfin-Chandler and by its predecessor court, the PCIJ, in the factory Troy case. But there is also a subjective standard that can be applied, that looks to what the states knew and the type of intent in violating any breach of international law. Benin has not breached any of its violations of international law. Opposing agents state that Benin has acted deliberately to attack Akira. There is nothing in the record that this Court should base that finding upon. Although the apogee of the satellite was above Akira, it was also above Benin. Benin and Akira are very close neighbors, less than 1,000 kilometers away. So, of course, a satellite in a highly elliptical orbit with an apogee above Benin would also be in close proximity to being above Akira. Furthermore, Benin, as stated in the record, had no interest in interfering with the CNAV signal, as its own military and civil programs were relying on that signal for navigation as well. Although there are certain coincidences that this Court can look to as circumstantial evidence to support the conclusion that the X-12A was the source of the electromagnetic interference, there is no adequate evidence put forth by Akira to support a finding that Benin was deliberately attacking Akira. even if it is determined that the use of force, or excuse me, a electromagnetic interference from a satellite, it can be determined to be a use of force. And to answer Her Excellency's question regarding where this court should draw the line when an instance of harmful interference becomes a use of force, it should be drawn at deliberateness. A use of force implies intent in taking the action, not an accidental use of force or armed attack. There's no intent or deliberateness here on the part of the United. But as the issue...
Counsel, if I may, could you please explain to the court? I understand, as you said, Minai has interest also maintaining the C-Navy symbol, as you're also using the symbol. In that case, do you think Minai also has the obligation and the principle of consultation and cooperation provide necessary technical data to Akira when it's claimed there is interference or EMI between your satellite and the symbol? How you see that and international space?
No, Your Excellency, Minai was not under a duty to provide that information. However, Minai has registered its satellites, as stated in paragraph 9 of the
Why do you think that Minai does not have that obligation?
Because Minai does not have, as stated in Article 9 of the Outer Space Treaty, Minai did not have a belief that its activities would cause harmful interference. That's in Article 9 of the Outer Space Treaty, states are required to consult with those other states parties which they have reason to believe would cause harmful interference. Here, Minai has registered the satellites with the ITU and its frequencies, and through the authorization process in the ITU, without objection by any state. And as opposing agents have noted in the memorials, there is a process for objections, but there's no indication in the record at any time that Akira or any other state objected to the registration of the satellites and their signals. Furthermore, Minai did fulfill its duty under Article 9 of the Outer Space Treaty to consult internationally and conduct appropriate consultations when undertaking outer space activities by ITU. The term appropriate consultation is not necessarily defined. However, this process through the ITU, which both parties have agreed to for registering satellites, lets states be aware of the frequencies and registrations of satellites being launched around them and should satisfy the appropriate consultation. Furthermore, Minai has complied with its duty to act with due regard with other states' space activities under Article 9 of the Outer Space Treaty and has not violated this obligation. Minai had
Why do you think that in terms of the principle due diligence, in this case, Minai still has no obligation at all to exchange data when serious damage occurs on part of Akira? Why do you think that due diligence, the principle is so weak in this case?
Respectfully, Your Excellency, Minai had no reason to believe or to accept Akira's dubious claims of interference at the time. Now, the circumstantial evidence now available does support the conclusion that the X-12A was the source of the EMI. However, none of the coincidences that the Akira agents have pointed out were known to Minai at the time. Those were not included in the announcements to the international community by Akira, nor in the demarche issued directly to Akira, which coincidentally came after the complete inaccessibility of the CNET system. Article 15 of the ITU radio regulations lays out a very particular process by which harmful interference is to be reported. And that puts the onus upon the state alleging interference to provide full particulars of the interference it's experiencing. Here, it's not clear that Akira has submitted any of this technical data, which is referred to in Article 15 and laid out in Appendix 10 of the ITU radio regulations, nor has it provided any of the information of the coincidences of the overflights of the X-12A satellite and the zone of communication, a footprint of communication, to Minai at the time. Now, taking into consideration Akira's actions from the beginning of the compromise, which Akira's agents have neglected to inform this court of during its oral arguments, Akira has taken aggressive military action from the start, moving warships into the Langerhans Islands, which Akira agents have noted Minai and Akira have overlapping economic plans. and they have occupied this area for 3 years since 2014. Akira also flew Air Force Air Force planes onto the island and planted its flag, attempting to assert a claim of the Langerhans Islands. So perhaps Akira's perception of Menai's actions as a deliberate attack stemmed from its own actions, taking aggressive military action from the start, potentially some type of collective guilty conscience on the part of Akira.
Also, your opponents say that Menai was the appropriate state of the outer space treaty with the responsibility to continually supervise its nationals and its corporations. Do you accept that? And are those obligations contingent on notice by an effective state that there have been concerns about possible harmful interference or electromagnetic interference?
Your Excellency, Menai does not deny that it is responsible for the activities of state communications under Article 6 of the Outer Space Treaty, just as Akira is responsible for the action of its nationals, which were involved in the launch consortium under Article 6 of the treaty. Now, the notice provided by Akira was not sufficient to make Menai aware that it could actually that there actually was any sort of interference which it should take action to resolve. And this is where Menai asked the court to apply this subjective standard of fault, because Menai did not have knowledge of the coincidences which Akira now relies upon. And harmful interference in and of itself is not a violation of international law. Article 45 of the ITU Constitution states that states parties shall carry out activities in such a way as to not create harmful interference with the activities of other states. But read together with the object and purpose of the convention and the processes for reporting and resolving harmful interference through cooperation and mutual assistance, and discussions in Resolution S735-1 of the ITU radio regulations, it is clear that there are permissible levels of interference, and interference in and of itself is not a violation. Here Menai had no reason, in fact had reason to doubt Akira's claims because of its aggressive action from the start to keep Menai from being able to access the Langerhans Islands with its sailing warships into the archipelago and flying transport vehicles onto the island as well. Furthermore, the damages alleged are not those contemplated under the outer relevant space law treaties. EMI is not a space object in these instances. The outer space treaties require that damage be caused by a space object. Now, the Liability Convention in Article 1 defines a space object rather circularly as a space object or its component parts in the launch vehicle thereof. EMI is not a component part of a space vehicle, or excuse me, a space object, but rather is a non-tangible, non-physical energy signal emanating from the object. And in fact, the ITU evinces an intent to regulate.
Isn't it the property of the space object? Say the signal is intangible, it doesn't exist, material, almost as a ghost. But I think it is a property nowadays of any space object to have certain signals sent out and received. So you cannot divorce the space object from the electromagnetic signal. And your position seems to be very stringent. It's just a piece of metal. Maybe you could resort to a evolutive interpretation of the relevant treatise rather than to stick to this very narrow approach.
Well, respectfully, Your Excellency, the ITU evinces an intent to regulate radio broadcasts such as would cause electromagnetic interference outside of the confines of the Liability Convention, and not to be included as under the definition of space object. They regulate harmful interference specifically in radio broadcasts, specifically in the ITU, as a separate document from the Liability Convention. So it is Menai's position that electromagnetic interference or radio signals should not be regulated as space objects, but be regulated under the documents that the states parties have both agreed to for these purposes. And furthermore, to that point, Article 36 of the ITU Constitution, in fact, states that member states accept no responsibility towards users of the international telecommunication services, particularly as regards claims for damages. Now, this has recently been noted by space law scholars as potentially creating a regime where there is no liability for harmful interference and damage caused thereby that this court could look to absolve Manai of its liability. Furthermore, there is no physical damage to Akira when its CNAP signal has been rendered inaccessible as it issued in the first submission, the inaccessibility of the CNAP signal. There's no physical damage as is required by the Liability Convention, which defines damage very specifically in Article 1A as the loss of life, personal injury, or other impairment of health, or loss of or damage to property. There is no loss of the satellites. There is no damage to the satellites. There is interference that is intermittent and without cooperation between Akira and Manai by Akira properly reporting and Manai being required to take any sort of action. This is just interference that escalated to inaccessibility of the signal and no longer exists. There is no physical damage as is required by the Liability Convention.
Counsel, what if we disagree with your statement that physical damage is required? That would have to be right.
Even if there is, even if physical damage is not required, Manai is not liable because it is not at fault for the inaccessibility of the signal because it has not reached any of its international obligations. It is complied with the ITU Constitution Convention. It is complied with provisions of the Outer Space Treaty and the Liability Convention. So fault cannot, liability cannot stem when there is no fault.
How can that be when there's a specific provision in space law that says that there's strict liability?
That is an absolute liability standard under Article 2 of the Liability Convention for damage caused from the surface of the Earth, which would apply to the third submission to this court regarding the crash of the unmanned aerial vehicle. Here, it is Manai's submission that Article 3 of the Liability Convention applies to the inaccessibility of the CNAP signal because it is a fault-based regime for damage that occurs elsewhere than on the surface of the Earth. If Akira is to assert that there is damage to its satellites because of interference, as it has in its memorial, then there must be fault on the part of Manai, which connotes in the objective standard a breach of international law, or under the subjective standard a breach with some sort of requisite intent. Neither of those is the case here. Furthermore, Akira is a joint launching state, as your excellencies have discussed with opposing agent, and as such has impliedly consented to the activities of the X-12A and X-12B satellites, and any interference resulting therefrom. Under Article 5 of the Liability Convention, when states jointly launch a space object, a joint and several liability applies. And states should not be permitted to recover damages damages caused by a space object over which they had some level of control. Akiran entities, Akiran corporations are involved in the Joint Launch Consortium which launched the X-12A satellite. Furthermore, the X-12A satellite was launched from a floating platform within the Langerhans Islands, which Manai has attempted to assert a claim over. Now, under Article 5.3 of the Liability Convention, launches from territories or facilities of a state, but those states will be considered a launching state. So because Manai has corporations involved in, Akira has corporations involved in the Joint Launch Consortium, it is responsible for those corporations' activities under Article 6 of the Outer Space Treaty, and furthermore is considered a launching state because it is launched from territory which Manai or Akira.
Let me answer this question. This is a very important part for the determination of liability launching state. How do you see that under outer space law? If Akira is a joint launching state, why only Manai acted as a state of registry? How do you distinguish that? Because this is apparently very crucial matter. And in other words, when they say communication under direct control of Akira or under the direction or control of Minai. So this is something you have to be very clear and in terms of in legal terms.
Yeah, sure. See, and as to your first question, a state can be a launching state and not the state of registry. Under the registration convention, when there are multiple launching states, the states agree jointly who will register the satellite. So a state can still be the launching state, even if it is not the state of registration. There's to be only one state of registration to avoid confusion in the United Nations registries. I'm sorry, Your Excellency, could you remind me of your second question?
Yeah. But my second question is, of course, I asked you how you distinguish a state of registry and a launching state. And now, with the same communication, the company, you do have a private company from Akira. To what extent Akira should be responsible for that company? Is that company under direction and control of Minai or under Akira?
The corporation, Say Communications, is a Minai corporation, so Minai would be responsible for its activities. It's not clear to what extent the Akira corporations were involved in the operations of the X-12A, if at all. However, it still makes Akira a launching state because it is responsible for its national activities under Article 6 of the Outer Space Treaty, and because under Article 5, Sub 3 of the Liability Convention, was launched from a territory which Akira has asserted a claim over. It should be stopped from denying that it is launched from its territory. In that sense, under the Liability Convention, read by the plain language of those words, a launching state is liable for damage caused by the space subject. I see my time is running short. If please, the court may move on to the issue of the crash of the UAV. Your Excellencies, Minai submits to this court that Akira has not submitted any credible evidence that the X-12A electromagnetic interference caused the UAV to crash. Opposing agents state that this is undisputed. However, that is not the case. This is not stated clearly in compromise that the UAV was the cause of the crash. Or excuse me, the EMI was the cause of the crash. An out-of-court report by Aviation, Daily, and Space Operations noted that some interference caused disruptions in the signals that Akira was experiencing, and also caused the crash of the UAV. This was corroborated by Akira's own conjecture, by its own analysts, without any further technical data put forth. Although circumstantial evidence can be relied upon, as this court stated in Court Food Channel, that is where it leaves no reasonable doubt or other reasonable inference. There are various causes of electromagnetic interference. There are various causes of crashes of aircraft. It is not, this court should not jump to the conclusion where there are other possible causes, and it is not necessarily foreseeable that electromagnetic interference would cause the crash of an unmanned aerial vehicle, particularly as there is industry standard technology available and has been for over 15 years to prevent just this type of crash. It is not foreseeable that a properly registered satellite, a conventional communications satellite broadcasting a signal, would eventually cause the crash of an unmanned aerial vehicle and any resulting deaths and property damages. Furthermore, if Akira had chosen to fly an unmanned aerial vehicle with navigational troubles in this environment of electromagnetic interference, this could be some sort of contributor. I see my time has expired. May I briefly conclude my point, Mr. President? Akira's UAV, or choice to fly a UAV with these navigation projects, relying solely on the satellite. There are standards in place for the satellite to be relied upon partially for correction in navigation algorithms. It is not foreseeable that it would cause, that EMI would cause the crash of an unmanned aerial vehicle. And further, that this could rise to some level of gross negligence by Akira to choose to fly this craft in this environment, which would absolve Minai's liability under Article 6 of the Liability Convention. If there are no further questions, Your Excellencies.
Thank you.
Thank you.
name is Jessica Fernandez, and along with my co-agent, I too represent the Commonwealth of Manhattan. I will be addressing the second submission to the court, demonstrating that Akira acted in violation of international law by disabling the X-12A satellite and ultimately resulting in its destruction. First, I will address the international obligations that Akira has failed to comply with. And second, I will address the fact that Akira's actions cannot be justified under any principle of international law. With the court's permission, I would like to proceed to my first point. The fundamental principle in international law is international cooperation. It is an enumerated purpose of the UN Charter. In fact, the IT Constitution itself required that states use space for peaceful purposes and internationally cooperate with one another when required. Akira violated its duty to internationally cooperate with Lanai through its deliberate destruction of the X-12A satellite. The record is replete with evidence to indicate that it was Akira's intent all along to destroy the X-12A. First, as indicated in paragraph 11 of the compromise, Akira was aware that the X-12A would process the new CNAV-2 signal because Akira knew that there were M2 tuners aboard the satellite processing the signal. Instead of protesting the use of these M2 tuners at the time that Akira learned of their use, Akira used this information to its advantage and subsequently launched the CNAV-2 signal that would be processed by the tuners. Second, as indicated in paragraph 16 of the compromise, Akira waited until the Klondike satellite was in orbit in near conjunction with the X-12A to broadcast the new signal. Third, and most important, Your Excellencies, Akira never apprised Lanai of any of the facts which it is now raising before this court. For example, Akira never informed Lanai that the only receivers affected were within the communications footprint of the X-12A. Akira also never informed Lanai that the overflight of the X-12As were coincided with the EMI. Additionally, as stated in paragraph 14 of the compromise, it was Akira's unannounced intent to counteract and neutralize the effects of the EMI. The only announcement that Akira provided to accompany the launch of the CNAV-2 signal was that the signal would be used to patrol the waters around Akira and the Laramie Islands, and it would be used in support of its expanded drone program. Akira never informed Lanai of its intent to launch this new signal to counteract and neutralize the effects of the EMI. Additionally, in paragraph 10 of the compromise, when Akira issued over the Laramie Islands and to launch the new signal in support of its drone program, it is clear that it was Akira's intent all along to disable the X-12A satellite. This violates Article 1 of the Outer Space Treaty because it interferes with Lanai's right of equitable access to outer space and its right to freely explore outer space. Additionally, Akira violated Article 9 of the Outer Space Treaty, which requires international cooperation and consultations when engaging in space activities that would result in potentially harmful interference to other states.
For the EMI that causes damage to Akira. Let me ask you this question. Under international space law, is it wrongful for a state, in this case for Akira, to launch a satellite, a signal that it considers harmful to itself?
Yes, Your Excellency. In this instance, that does violate international law because it was Akira's intent to directly cause harmful interference with Lanai's satellite.
Counsel, what if we conclude that there was no such intent? Does that mean that we should decide in the other side's favor, or should your side still?
Information Akira possessed that would support the X-12A was causing this EMI and causing the inaccessibility of the CNAV signal.
But counsel, again, your co-agent a moment ago said,
not only were there less drastic alternatives available to Akira at the time, but Akira itself contributed.
In this case, for Akira to launch a satellite with the signal that would neutralize or counteract a signal that is considered harmful to itself?
Yes, Your Excellency. In this instance, that does violate international law because it was Akira's intent to directly cause interference with the ninth satellite.
What is the difference that the West has had on does that mean that you decide in the other side's favor, or do you decide some of the mail and so on?
No, Your Excellency. Even if this court were to find that there was no intent on the part of Akira was still in violation of international law because under Article 9 of the Outer Space Treaty, Akira was still under the duty to conduct international consultations with the nine because its launch of the CNAP-2 signal would potentially cause harmful interference to the X-12 satellite. So even if this court found that there was no intent, Akira still violated international law by way of violating Article 9 of the Outer Space Treaty.
Council, you have explained what's wrong with the state to launch a satellite that simply to counteract or neutralize a signal that considered as EMI to itself, not targeted at a particular satellite, just to neutralize the signal. What's wrong with that?
Well, Your Excellency, the phrase counteract and neutralize the EMI certainly connotes an intent to attack or eventually disable the satellite, which it believed was causing interference with its own state. Here, although Akira intended to counteract and neutralize the effects of the EMI, Akira never made Manai aware that this was its intent. Because Akira knew that counteracting and neutralizing the effects of the EMI would cause the X-12A to interpret a new signal and could potentially cause harm with the X-12A, Akira was still under the duty to consult with the nine prior to this launch, instead of simultaneously announcing that it would be launching the signal as the satellite is being placed into orbit. If I may move on to my second point here. Akira's violation of international law cannot be justified under any of the principles the court has recognized. First of all, Akira's actions cannot be justified under self-defense, because as Article 51 of the UN Charter requires, self-defense must be in response to an attack. Here, the compromise has no evidence to support that Manai was by any means attacking Akira, and agent for Akira has not provided any proof that this was Manai's intent. So Akira cannot come before this court now claiming that it was acting in self-defense when there has been no attack on the part of Manai. This is also supported by the fact that the compromise has no indication that that Manai had any deliberateness to engage in such attack. Secondly, as Mr. President raised earlier, Akira cannot come before this court claiming that its action is justified under the principle of countermeasure for several reasons. As this court addressed in the Gabjakovo-Nagamoros project, when Slovakia tried to justify its actions through the principle of countermeasure, there are several requirements that a state must meet in order to comply with a valid countermeasure. Mr. President raised the requirement of reversibility. This, coupled with Article 49, Section 3 of the UN Resolution on State Responsibility for International Acts, which requires that a countermeasure shall, as far as possible, be taken in such a way to permit the resumption of the performance of the obligations in question, certainly leads to the conclusion that Akira cannot meet these requirements because Akira's alleged countermeasure resulted in the destruction of the X-12A, making it impossible for Manai to comply with any sort of cooperation or even attempt to reverse the problem because the X-12A was no longer in existence. Secondly, Akira did not comply with the requirement that a countermeasure must be announced prior to engaging in it. The lack of notice is evident in paragraph 14 of the compromise, as if the record indicated that it was contemporaneous to the launch of the satellite that Akira made any sort of announcement that there would be a CNAP-2 signal being broadcast. Additionally, Akira cannot claim now before this court that it was engaging in a countermeasure when it never apprised Menai to begin with of all of the information Akira possessed that would support the X12A was causing this EMI and causing the inaccessibility of the CNAV signal.
Further, Excellencies, we submit that the procedures of the registration of any space object or frequencies before the International Telecommunications Union are by themselves not indicative of adherence to law. There are two problems with ITU procedures. Firstly, that the ITU has no coercive powers to collect evidence. And secondly, and more important, there is no enforcement power vested within the International Telecommunications Union, something that can be evidenced by the respondent's refusal to adhere to the protocol of compulsory settlement of disputes. Given that the ITU has no enforcing power, we submit that mere registration of frequencies with the ITU is not prima facie indicative of legality of operation of those frequencies. Thirdly, Your Excellencies, with regard to the respondent's arguments that damage must be limited to physical damage, we submit that the trago of both the Outer Space Treaty and the Liability Convention specifically excludes this conclusion, given that the word collision in the Liability Convention was replaced by the word cause, and both the liability regimes under the Outer Space Treaty and the Liability Convention are in fact victim oriented. Further, Your Excellencies, we believe that even if Akira is a co-launching state, under Article 7b, the extent of Akira's liability is limited to the participation of the Akiran entities, and the compromise only indicates that the Akiran entities participated in the launch. There is nothing to support a conclusion that any entity apart from CERN Communications owned and operated the satellite once it was in orbit. And in terms of the argument of gross negligence, Your Excellencies, nothing in the compromise indicates that the standards that the respondents wish the applicants to adhere to were not met. The compromise merely states that irrespective of what standards were taken or weren't taken, the electromagnetic interference caused the crash. And the biggest proof of this within the compromise, Your Excellencies, is the fact that the EMI ceased once the X12A satellite was destroyed, something we believe is fundamental in our understanding of this case. Lastly, Your Excellencies, respondents have repeatedly referred to the fact that they had no intention to cause damage to our signal or to our entities or to any of Akira's entities. We submit that it is not menial intent that is of any relevance to this code. What is of relevance, on the other hand, is the intent of CERN Communications. And much like my co-agent argued, the fact that they have lucrative stock options in a drilling enterprise that subsequently drilled in the archipelago, and the fact, Your Excellencies, that oil is involved, is enough of a motive and intent to not only violate corpus juris specialis, but also to illegally use force and to commit an armed attack. With this, Your Excellencies, yes.
Thank you.
Thanks, Mr. President. Your Excellencies, I'm only going to address a few of the points that opposing agent brought on the road. First, opposing agent claims that the information required under the IG was provided to Menai. However, because this compromise was stipulated and agreed to after the fact, it is certainly reasonable to suspect that had Akira provided this information that would essentially be dispositive in this case, it would have included it in the facts of the compromise. However, those facts are missing, and that indicates that that information was not provided to Menai. Second, the ITU does not have any enforcement mechanism, but that is simply because it relies upon the international cooperation of states. In this case, Akira did not cooperate with Menai in support of all of its international duties. Also, Your Excellencies, opposing agent raised Radio Regulation 15.37 as requiring the state that could potentially be the source of the EMI to conduct an investigation, but it is important that this court be aware that duty to conduct an investigation is only triggered after the alleged state provides the other state of the harmful interference that it is alleging, in accordance with Appendix 10, which lays out all of the technical data that is required. Additionally, Your Excellencies, Menai's failure to take action to eliminate the EMI was only substantiated as coming from the X-12A after the X-12A was destroyed, cannot possibly be held as a failure to cooperate by Menai as required by the OSC. Because again, all of these facts are known now, after the matter. When Akira first learned of the EMI and was first experiencing the EMI, that is when Akira should have gone directly to Menai and provided all of the coincidences it is now raising before this court to prompt Menai and to make Menai aware and to enable Menai to cooperate with Akira. Opposing agents also draw the court's attention to collision damages, but it's important to note that there is a difference between collision damages and physical damages. And in this case, in this state, physical damages, Mr. President. Opposing agent is asking this court to extend this definition when there's no indication in the Civil Liability Convention that it should be extended to this form of damage. And lastly, Your Excellencies, the X-12A and the X-12B were identical satellites that were launched at the exact same time. But only the X-12A is seemingly causing this EMI, so at best, the evidence in the conference leads to the single conclusion that the X-12A was merely a malfunctioning satellite, not that the X-12A was deliberate interfering with any of Menai's space activities. And with that, if there are no further questions, thank you, Your Excellency.
Dear judges, dear students, dear audience, that concludes another Moot competition named after famous Judge Manfred Lachs, who was once president of this institute, as well as of the International Court of Justice and a great space lawyer. And we're very, very proud to organize every year this competition in his honor and to have 3 judges of the World Court with us each year, very faithfully, coming to faraway places and reading lots of memorials and listening to the arguments of the students in complex cases which have up to date not seen the light of day before the International Court of Justice. It's always interesting to hear the judges say, if ever a space law case is brought before our court, we will be specialists like that. And that consoles us a little bit in making me travel and come here all the way. We're very, very pleased to have had 2 excellent teams here in the finals this year. We also had 2 other teams. As you know, the competition is composed of several regions. We have Africa, we have Europe, we have North America, we have the Asia Pacific,
all in all, more than 60 universities worldwide that compete for, in many cases, over a year to prepare for this factually complex case, if I may say so.